has been here 31 years, and every time the PNM is in government, he has given us evidence that Senator Mark has maintained a consistent analysis of the PNM's inappropriate manner of legislating and trying to attack criminal elements. What Senator of the Minister of Agriculture has stated shows that no matter what, the faces may change in the PNM, but the PNM remains the same for decades, coming to trample on the rights and abuse the Constitution of Trinidad and Tobago, as we are here again today, so to do. This is a critical debate, yet I don't see the zeal from honorable senators to debate. In fact, I'm shocked that I'm here so early. I plan to talk maybe at 7 o'clock. But there is a reason for that. And I am also part of it here in the Senate. I look around and I see lawyers and doctors, PhDs and professors. I see business people. I see all sorts of intelligent people. But I don't see the people who will be mostly impacted by this bill. I don't see the people who, if you take a little jaunt, a little walk down the street by the magistrate's court, I don't see those people. So I don't think that we are getting a representation of those who may not have lawyers on speed dial. I too. I have lawyers on speed dial, father, brother, sister, son, everybody. But the people who are going to be affected by this most important bill are not represented here in the upper house. We are in the upper house as we've described, and we have certain abilities and certain opportunities that other citizens may not. So we need to spend and spare thought for them, because it's their lives that will be impacted by this bill. The Senator, the Honorable Renuka Sagram Sim Sukral, last week said in a powerful, passionate, and I dare say loud contribution. I think she was louder than me, but she was brilliant. But she said, you need this bill to give the police teeth. But unfortunately, in Trinidad and Tobago, many police teeth are rotten, and them need dentures. The Constitution is the toothpaste, the dental floss, and the mouthwash to protect the citizens from the decay. Yet I come here and I hold two bills in my hand, one from 2019 brought by the very PNM, and this one here today, 2020. But the explanatory note in 2019 said this bill seeks to amend the Evidence Act, Chapter 702, to provide for the use of different identification procedures, interviews, and oral admissions, special measures, the taking of evidence by video link and witness anonymity orders. The bill would be inconsistent with Section 4 and 5 of the Constitution and is therefore required to be passed by a special majority of 3/5 of the member of each house. But then I come here a year later, and the same Attorney General in the same government bringing basically the same bill with even more draconian measures to impact the rights of citizens. That is eliminated. Then we begin in 2020 the Evidence Amendment Bill. The bill seeks to amend the Evidence Act, Chapter 702, to provide for the use of different identification procedures, etc., but simply eliminates the constitutional majority. And we come here to debate this. And my honorable colleague, the Minister of Agriculture, speaks a passant, that we are just to make laws up in the sky, in the cloud of the upper house, but not worry about how it impacts people down there. That's the problem with the PNM, because you only worry about what you have to do and what affects you. We have to worry about all the citizens out there. George Jelinek, one of the greatest constitutional experts, wrote the essence of this Constitution. And this Constitution, Minister of Agriculture, while you're eating your local doubles, you should read it and study it. Then you will make more impassioned contributions that I could listen to. He said, the legal precepts are incapable of actually mastering the distribution of power within the state. In Trinidad and Tobago, we are seeing a massacre of the distribution of power. We are seeing the haves going higher and the have-nots going lower. We are seeing those in business rising and enjoying while others are suffering. And we come here today to widen the gap once again. He said the actual political forces move according to their own laws, which operate independent of any legal form. We'll get into more detail with that. Thirdly, he said the problem between is the ought and the is. The ought is the Constitution, the basis, the law. We ought to be here making laws to deal with the criminal element properly while respecting everyone's constitutional right. One is innocent until proven guilty, and you cannot just create shortcuts because the job is difficult. You may put an innocent human being in jail because you need a shortcut. Shortcut is for traffic, not for laws. In 2021, under the PNM, the ought is a long forgotten dream, and the is incompetence, dictatorship, disdain, and very dangerous. And according to the President of the Republic of Trinidad and Tobago, and I quote, dotish, the Constitution is the legal order of a state, or the life through which the state has the reality. This Constitution, which some of us seem to just discard, throw away, this is the supreme law of our land, and everything we do here must uphold this. But we just eliminate it and come here with two case, same argument all the time, and eliminating rights of citizens. Yet today, once again, we enter the hallowed halls of the Senate, created and maintained by the Constitution, to continue the diabolical policy of this PNM government to desecrate, demean, and devour the very essence of that which makes us who we are. Number one, the legal precepts are incapable of actually mastering the distribution of power within the state. What does this mean? In this evidence bill, for example, we look at the entire essence of what they're doing, and we ask the question, what has prompted these measures? Is there a zeal to throw out tried and tested legislative safeguards for an attempt at optics and microwave justice? Why are we taking shortcuts? The tried and tested court judiciary system is there to protect citizens, to make sure and ensure that those who are guilty are punished. Our Constitution, in the preamble, Section B states, and let me read it because we are here making laws and like we forget it. B, respect the principles of social justice and therefore believe that the operation of the economic system should result in the material resources of the community being so distributed as to subserve the common good, that there should be adequate means of livelihood for all, that labor should not be exploited, Roger, or forced by economic necessity to operate.
Senator Roberts, you are reading a lot, but now you're getting irrelevant. You're not linking what you're reading to what is before us. So I'm going to ask you, please, to try and be a little more relevant to the bill at hand.
Madam President, I cannot say that my Constitution of the Republic would ever be irrelevant, but I am saying...
Senator Roberts, please, just take my advice and move on.
Thank you for your advice, your timely advice, Madam President. The evidence bill is here and is creating a divide between the haves and the have-nots, and it's ironic that a bunch of haves in the upper house are making laws for the have-nots. There's a difference in Trinidad and Tobago between zesters and westers, how the law is applied. We see that daily. We see recusal twins getting rentals, recusing themselves and their families receiving millions and billions.
Senator Roberts, please. You are being completely irrelevant to the matter at hand. Please confine yourself to the remit of the bill.
Thank you, Madam President. Let me get back to the bill. In this bill, the evidence bill, we see that the proponents of this bill must be careful, very careful, that they're not hoisted by their own petard. You do not pass fast and convenient law because you think you are in power. You must pass law that can withstand scrutiny of generations, can withstand the imposition of menaces in office. We have been provided with no meaningful suggestion or rationale as to why the wholesale changes have been made. There is tinkering with the justice system at the behest of the Attorney General, an Attorney General who holds political office and whose political fortune lies therein. Yet we see in section 12AA of this bill, for example, a witness anonymity order. This provided that where there are reasonable grounds to believe that the identity of a witness should be concealed from an accused person and the public as to protect the witness, any of the relatives or any person, the court may grant a witness anonymity order. Such a provision in this country,
Madam President, 46.1, please. I think he's reading from the wrong bill.
Senator Roberts, I think you need to refer to the clause, because I too am having a little difficulty understanding which part of the bill you're dealing with.
I'm comparing the 2019 bill with the 2020 bill at section 12A. But it's all right, I'll move on. The problem with this bill is that the ought and the is are separate, and that this bill is a shortcut to getting convictions or getting people to be arrested, indicted, charged, and convicted. Shortcuts have dangers, and citizens will suffer if we do not carefully analyze some of these laws. This government is suffering from a low detection rate and needs to make political moves to say that they are attacking crime. They have already stated here in this Senate that they have attacked crime under COVID-19 lockdown for 11 months. They brought the anti-gang bill and it had failed dramatically. We saw no increase in convictions, but we saw a diminution of the rights of citizens. This government is a government of shortcuts. It was too difficult to test, for example, in COVID-19, to test and contact trace. They took shortcuts without testing. Now we come here to bring legislation that brings shortcuts in a critical area of the judiciary. In section 12N1, the identification in a public place, for example, under this section may be conducted without the consent of the suspect, where the identification procedure under this section is to be done without the consent or cooperation of the suspect. The identification officer shall ensure the procedure is carried out in the presence of the justice of the peace. The conduct of an identification procedure under this section without the consent of the suspect may only be conducted where A, the suspect is not in custody, or B, the suspect has refused to give his consent to the conduct of a procedure under section 12M, or impossible or impractical to obtain the consent. In a practical sense in Trinidad and Tobago, how will this be done in public without the suspect knowing some justice of the peace is required to be present? This seems farcical and very dangerous. Have the powers that be considered this in a practical fashion as to how this will be done. Or the cynic will say, once they check the boxes of the requirements, the suspect could be identified in public with him or her knowing. One reads the papers with many confessions having been thrown out of the court, despite confession being supposedly witnessed by a justice of the peace. This is very critical to evidence. Just coming here last week, for example, I was speaking to a police officer and having a full conversation. And he said, but Senator, what are you doing here? We got notice that you would not be here. Then I realized he thought I was Senator Naked. This is a very serious situation with identification. Today, coming into the Senate, I walked in I did not go to get my temperature. I came back to a police officer to say, please check my temperature. She said, but I checked your temperature. You were certain.
Senator Roberts, you have 5 more minutes.
She was certain that she had checked my temperature. I said, no, ma'am, check it for me again, please. Now, she did not do that with malice, but witnesses are sometimes mistaken, and by making shortcuts, bringing a bill here that does not allow for the rights of citizens, especially under cross-examination, or to have their attorneys present, and settles for justice of this peace, or video recordings that cannot be checked, is very dangerous. Witnesses do not have to be malicious. They could be mistaken, like today, coming in here. I recall a case, a very serious case in Trinidad and Tobago, where 2 PNM ministers were accused of doing wrong. Had this bill been in place back then, they may have been in another place. But under cross-examination, when evidence was given that somebody was collecting money by Smokey and Bunty, $13,000 and so on, when the witness went into court, the lawyer under cross-examination was able to prove that one of the ministers, PNM ministers, was not even in the country. In fact, was in Nigeria at the said time that the witness said he had given him certain amounts of money. And that cross-examination freed an innocent PNM politician and another one who is here today in the Senate because of the laws of natural justice, which this bill here is trying to eliminate. If this bill was the law back then...
Senator Roberts, you have 3 more minutes. Can I ask you, please, to lower your voice? Okay?
I thought I was trying to match Senator Renuka Sagram Singh, but I'm sorry, I'll talk short.
Senator Roberts.
Yes, ma'am. What's that?
Senator Roberts. Senator Roberts.
Yeah.
You have 3 more minutes.
Thank you.
No, Senator Roberts, I'm sorry, your time is up. Attorney General.
Thank you.